Professor Larry Helfer, and on behalf of the Center for Law Ethics and National Security and the Center for International and Comparative Law, I'm delighted to give a few introductory remarks for today's lecture by Professor Kurt Bradley, which honors the publication of his new book, International Law in the U.S. Legal System, out last month on Oxford University Press. Just will say a few words to situate the remarks that will follow. Since the beginning of Professor Bradley's academic career in the mid-1990s, he has written about virtually every aspect of the role that international law plays in the U.S. legal system. And I think a theme, probably the most predominant theme that runs throughout his scholarship, is the distinctive approach that the United States has with regard to international law and institutions. This distinctiveness applies to how the United States negotiates and enforces international legal rules and its membership in multilateral organizations, but it applies with special force to how international law is incorporated into U.S. law. That is how international law becomes part of the domestic legal order in this country. So consider just a few examples. Treaties and executive agreements. Much to the consternation of some of my students, those are both international agreements binding under international law, but they have very different distinctions in the domestic legal, differences in the domestic legal order. So that's quite a distinctive feature. Federalism. Can the United States, a treaty of the United States, expand the scope of federal power vis-a-vis the 50 states, an issue that's now pending before the U.S. Supreme Court? Separation of powers. What are the respective roles of Congress and the President in making, applying, and enforcing international law? And relatedly, judicial enforcement. What role should judges have in enforcing treaties and customary international law, especially in the important but politically charged area of human rights? Professor Bradley has written eloquently on all of these topics and many others, and his particular expertise has been to map the interface between public international law and the U.S. constitutional law of foreign relations. Professor Bradley's deep knowledge of both of these fields, as well as federal courts and jurisdiction and other areas, has sometimes led him to challenge received wisdom, such as the status of customary international law as federal common law, or the interpretation of legislation, such as the Alien Tort Statute. But even when taking on seemingly settled understandings of these and other issues, Professor Bradley is always careful and measured, and he expressly considers contrary arguments and their implications. As the reach of international law has expanded dramatically over the past couple of decades, the volume of litigation in the United States raising international law issues has also increased dramatically. This is demonstrated not the least in the number of blockbuster decisions of the U.S. Supreme Court relating to treaties, human rights, and the transborder dimensions of national security, to name just a few. I think it would be an understatement to say that Professor Bradley's scholarship on these and other areas has been highly influential. Just one indication of that influence has been the number of times that his articles have been cited by judges. I did a quick Westlaw search this morning and found more than 125 citations to his work, many of them extensive quotes or discussions of his ideas, not just citations. Now, in his new book, International Law in the U.S. Legal System, Professor Bradley takes stock of these developments, as his talk refers to 20 years of these developments, and synthesizes more than 2 decades of his writings on these issues. And these publications especially timely, as Professor Bradley co-leads a team of scholars who will be drafting the Restatement 4th of the Foreign Relations Law of the United States. The book is, in short, a tour de force, incisive, extensively researched and balanced, and it discusses the length and breadth of international law in the United States. I don't think I have to go out on a limb in saying it's going to be widely read by judges, lawyers, students, and scholars for many years. So please join me in welcoming our own Kurt Bradley.
Thanks so much, Larry, for that introduction. Thanks, everybody, for coming. And I'm going to talk about my new book, which is International Law in the U.S. Legal System, maybe for about 40 minutes. And if there's time at the end, I'd be happy to take questions. The book addresses, as Professor Helfer mentioned, topics I've been focused on for about 20 years. The story, in fact, begins almost exactly 20 years ago when I was an associate at a law firm in Washington, just having freshly clerked for a couple of federal judges. And I was co-teaching a class as an adjunct professor at the University of Virginia Law School with a good friend of mine who had also clerked the same year as me, Jack Goldsmith, who's now a professor at Harvard Law School. We had clerked together. He was now at the law firm, and we decided to teach a class together. It was a class in international civil litigation, and we'd actually, to try to fit it with our busy schedule, we would teach Friday nights and Saturday mornings. And to probably all of our surprise, students actually showed up Saturday mornings. We had huge boxes of donuts to help make that happen. It was a beautiful fall in 1993. We would drive from D.C. On Friday afternoons and try to get out of the office a little early. We sometimes actually rented a convertible for a drive to Charlottesville, make it as well as possible. I tried to actually find pictures of us driving the convertible to give you the sense. This is the best I could come up with. Is kind of the best thing I could find on the web. This is kind of a representation. So imagine that's us. Now, my wife, Kathy, who teaches at the law school, did see the slide and wondered about the passengers in the back. These really just represent the ferment of ideas on the trip. So we had a good time. We did actually argue a lot, friendly arguments going back and forth about international law and the U.S. Legal system, how the Constitution works when the U.S. gets involved in foreign affairs. We particularly focused on something that will sound kind of technical, but turned out not to be, as we discovered, which is the role of something called customary international law. There are basically two types of international law in the world. Treaties, everybody seems to know what treaties are, agreements between countries. But there's another vibrant body of international law that's just unwritten practices of nations that they follow out of a sense of legal obligation. And both of these forms of international law essentially have equal weight under international law. Each can bind nations basically to the same degree. And customary international law has historically, probably not today, but was historically the dominant form of international law. It regulates things like the extraterritorial reach of each country's national laws, the immunity that foreign governments receive in other nations' courts, various issues, many issues about the law of the sea. Today, and more controversially, it also regulates the human rights practices of governments in their relationship to their people. And our question was not particularly about some of the questions that have been raised about that as a body of international law, but about how it relates to U.S. law and what status it might have in U.S. courts. We looked, of course, you would look, of course, to the text of the Constitution. The Constitution has a supremacy clause that talks about certain kinds of law and what status they have in the U.S. The Constitution, of course, is supreme law. Laws of the United States, which typically means federal statutes, and treaties. So a form of international law that most people would know about are all part of the supreme law of the land, binding on the state courts as well. You don't find, of course, a specific mention there of customary international law, which would have been called back at the time of the Constitution the law of nations. Even for treaties, it turns out, and this has been developed in the case law, not all treaties can actually be enforced domestically. Not all treaties can be enforced in court. So a case not very long ago reminded us of this fact, the Medellin case. We've long recognized that only some treaties can actually be applied domestically. So we wondered about the role of customary international law, not specifically mentioned in the supremacy clause. The only place in the Constitution where it's mentioned is in the long list of Congress's powers in Article 1 has one power that's defining and punishing piracies. Turns out now to be a hot topic again, piracy. We're getting a lot of those cases, but offenses against the law of nations. Only place in the Constitution that talks about customary international law, called at that time the law of nations, is in a grant of authority to Congress. Even though the founders knew quite a bit about this body of international law, and it was really the dominant type of international law in the 1780s when the Constitution was written. This clearly means Congress can write a statute codifying at least criminal offenses against the law of nations, and it has done that from time to time. So our question was, what happens if Congress has not done that? If Congress has not passed the statute? Does customary international law have effects in the United States even outside of what Congress does? And to think further about that, I need to introduce something that most of you probably have run into, which are something called the Restatements of the law. The private group, the American Law Institute, has long put these out on a wide variety of topics, torts and contracts and a bunch of other topics. And they have one on an area that covers these issues, which is foreign relations law. And they've actually had two of these. The first one was published in 1965. because it was part of the second series they were involved in at the time. It's called the Restatement Second of Foreign Relations Law. It was the very first one. And then they have a new one. The latest one was from 1987, and it's called the Restatement Third of Foreign Relations Law. And as Professor Helfer mentioned, we're now beginning the work, probably a very long process, of thinking about a new fourth restatement of foreign relations law. But that was, nobody thought about that at the time when Goldsmith and I were starting to think about this. So we looked at the old restatement, the Restatement Third, 1987, and tried to figure out what it said about customary international law. So here are restatements. Here's what it says. It is now established that customary international law is a kind of federal law. It's like treaties, has supremacy, it creates federal jurisdiction, and the like. And so that is now established. That's interesting. We didn't know that it had been established, but that certainly said that. So that clearly means, if it's true, that any time these customary norms develop internationally, they should preempt any state law, North Carolina law, that might be in conflict, allow cases to be brought into the federal courts under federal question jurisdiction. The restatement actually even goes further in speculating and says, since customary law is equivalent to treaties internationally, maybe customary law can do what some treaties can do, which is to actually override federal legislation, the legislation of Congress, if the custom develops after the statute, or even override our treaties in the United States, because some treaties can override earlier treaties. So they say that might even be a possible implication. That would be dramatic. Unwritten developing norms of custom that the United States has not necessarily specifically signed up to, not only preempting the law of the states, but maybe even overriding what Congress has done. So we thought that's a significant proposition. What's the precedent for it? And one case is basically cited in the restatement, and I'll give you their sentence that they give you. It's based on the implications of the Supreme Court case called the Sabatino case from 1964. Now, immediately, if you remember what I said about the restatements, the Restatement Second, Restatement Third, the Restatement Second came out a year after that case and does not say anything about customary international law having any federal law status. So this is something that apparently was discovered even later, that there are implications in this case. What is that case about? It's about after Fidel Castro took power in Cuba. As you may know, the Cuban government expropriated a bunch of American property. And in that case, the question was whether U.S. courts would be willing to look at the lawfulness of Cuba's expropriation. And the answer was no. There's something called the Act of State doctrine that the courts have long applied that says we'll respect what foreign governments do in their own borders. And importantly, the Sabatino case says that rule is a rule of federal law with supremacy over state law. So it sounds like it might be relevant, except for a couple of things. First, the court in Sabatino goes out of its way to make clear the Act of State doctrine is not based on international law. In fact, it's based on domestic separation of powers considerations. So it's a little bit of a stretch to say that holding a federal law status for a domestic rule somehow means international law also has that status. But it's actually worse than that, because in that case, the main argument was that Cuba had violated customary international law in taking American property. And the Supreme Court refused to even look at the argument and certainly didn't apply any customary international law. The only dissent in that case by Justice White complained vigorously that they're just simply not applying customary international law, and he was right. So again, it'd be a little bit odd to think somehow that case, which was even before the last restatement, leads to the proposition that all of international law is automatically federal law when they weren't even willing to apply the doctrine in that case. So maybe there was more. We thought maybe there's just one site, but you could look through the restatement and find other things. And there were a couple of other things we thought about, in addition to wondering about the precedent, which is it seemed to us at least intuitively anomalous that all of this unwritten material that's developing on a day-to-day basis internationally would displace U.S. law without any congressional involvement at all, just because you persuaded a judge to do it. And remember, the only reference in the Constitution to this is Congress's power to bring this in and define and punish offenses against the law of nations. So we thought this, at least it seems anomalous, and we thought it particularly anomalous if one did this with the new customary international law, particularly in the area of human rights. Why? Well, back then when we were writing, the United States was reluctant to ratify hardly any of the human rights treaties that were being developed in this area. But when the United States has done so, the Senate and the President, just about every time, has said this treaty shall not be enforceable in U.S. courts. We'll comply with it if we can, but it's not something that litigants can use in American courts. So the political branches of the government, the Senate and the President, had consistently taken the position that this developing human rights law in the treaty area shall not have these domestic law effects. And the claim that the restatement seems to be making is, as long as you can call the human rights norms customary law, it will have these effects that the Senate and the President are trying to resist, even though if you ended up looking to what people cite for the customary law of human rights, it is heavily citations of treaties, the very treaties that the Senate and the President do not want to have this federal law effect. So we wondered, can litigants really get around what the Senate and the President have said just by relabeling human rights claims as customary claims and not as treaty claims, and then have the potential, for example, to override limits, or override death penalty laws, which is one effort that certainly people tried in the state level, by saying that there were emerging norms against the death penalty or some aspects of it internationally. So we had some questions about whether this would make sense, including from just a democracy standpoint, that if we're going to make big changes to social policy in the United States, should it be done through the kind of evolving norms of the international community, or should it have to be filtered through the elected representative bodies of the United States? We had intuitions that maybe the latter was right, but we're willing to be persuaded. So we found one other citation. By the way, I need to introduce Professor Henkin. He passed away a couple years. Really the godfather of foreign relations law, started writing on this topic in the 1950s, had a 50-year career of very prolific and important work, and ends up being the chief reporter for the Restatement Third of Foreign Relations. So he's a chief draftsperson for this last restatement that is saying this is all federal law. And he's doing part of the citations. He also had written a very famous article before the restatement's finished, claiming that international law did have this federal law status. So we wondered what he's going to cite besides Sabatino, which we didn't think was very persuasive. And here's what we found, is that he cites, you can see what we go to his article, which is the other thing that's cited in the restatement. They cite Sabatino and Henkin's own article. And he, in fact, says there's now general agreement. It's federal law, not state law. Footnote, and here's your citation. Tentative draft of the restatement. So just to get it clear, the restatement cites actually his Michigan article from 1984. It has now become settled that it is federal law. We go back and look to the page of Henkin's article. There is now general agreement. Footnote, the tentative draft that they had circulated of the restatement. In finding that, at least what appeared to be some kind of circularity, that certainly made the car rides in the convertible more exciting. There was more yelling. We thought we had something at least to explore. So we thought we were onto something. And I had also taught federal courts as an adjunct, and this claim that all of customary law is just automatically federal law, if anybody's taken federal courts, you should know, it doesn't sync well with the aesthetics, the general intuitions of the federal courts doctrine. Why? When they talk about federal common law in federal courts, it's supposed to be interstitial, filling in the gaps of the policy decisions that the President and the Congress have made. There was nothing in the restatement about merely filling in gaps or going along with the policy wishes of, say, the Senate and the President on the treaties, but rather some kind of automatic, self-executing customary international law. It didn't seem to sync well with federal court. So we put all that together, wrote an article, was published in early 1997, critiquing the restatement, basically, and its propositions that it's federal law on historical grounds and structural grounds and what we thought was a lack of significant precedent for this. We were just starting out. I was not tenured at that point, so maybe this was a bit risky. We wanted, as young professors, I'm sure we wanted to get attention. I think we got more than we even wanted at that point. And it was not all kind or very friendly. We immediately sparred with somebody you probably know from more recent news days, Harold Coe, who at the time was a professor at Yale, and he's back to Yale now, but he immediately took us on in the Harvard Law Review and wrote a response, quite critical one. He's gone on to fame, of course, as the legal advisor in the last 4 years in the State Department, now being associated with things he may not want to be associated with, like targeted killings and drones and things like that. But at the time, he's a major human rights advocate known around the world, helps run a human rights clinic, and is quite unhappy with our paper, and writes an article, is international law, really state law. That's actually not what we said, but he got to choose his title, so he said we're being crazy. And his article is quite interesting. I think he wrote it quickly. Maybe he was so unhappy he just dashed it off. but it has that quality that, can you believe what they're saying? And you know it has that quality because, strange for a law review article, it's filled with exclamation points throughout the paper. And I'll even show you. And remember, junior, untenured faculty members, first big article I had ever written, even casual reflection compels the conclusion that Bradley and Goldsmith are utterly mistaken. Ouch. I mean, there's not a lot of generosity in that sentence. But then for the proof, if customary international law is neither federal nor state law, unless somebody's actually incorporated it, then in most cases, customary international law is not United States law at all. Like, an exclamation point, like that would be the most obvious absurdity one could ever imagine. We actually didn't understand the exclamation point. What's your point? And we wrote a reply that said, tried to just be very much on the merits, but did point out that we thought sometimes those exclamation points were doing a lot of work instead of analysis. That wasn't the only one, however. There's a person who's now teaching at Harvard. He was at Columbia, Jerry Newman, another senior scholar, an immigration scholar, quite unhappy with us, wrote an article, Sense and Nonsense About Customary International Law, a response to Bradley and Goldsmith. It's clear he thought we were mainly full of nonsense. There wasn't a lot of sense. Not this Newman, by the way, from Seinfeld. Definitely not that Newman, by the way. Here's a flavor. Much of what Bradley and Goldsmith add is seriously in error and is embedded in a bizarre conspiracy theory. Cool. We weren't even sure what that meant, but it sounded like we did something bad. Now, they're spelling our names right, and in that sense, who's going to be too unhappy just starting out, although it is intimidating for these senior scholars to say we were so mistaken. Our perception, to step back from it at that point, given this reaction, was that the international law community, even though full of great, talented people, was highly insular when we started writing in the mid-1990s. At least in many respects, an echo chamber of communication of things everybody already agreed about, and they did not, at least in our view, respond well to efforts to kind of rethink things that they had been taking for granted. And there are reasons for that. The world is kind of skeptical sometimes about international law. The press is skeptical. And it might be understandable that people who dedicate their lives to it have a kind of defensive posture and do not respond well to their own people in their own academy adding to the voice of skepticism. And I understand that. There was a sense, we thought, that to be a good international law professor meant to be kind of a cheerleader for your discipline that's under siege, and we were viewed as not doing our cheerleading role adequately. We also got a number of articles writing about something like, how dare they introduce constitutional technicalities to something so important as international law, technicalities such as citing obscure Supreme Court decisions like Erie Railroad against Tompkins. Literally, that's what they said. So we engaged with our critics. We did the best we could. It helped us quite a bit that we got this reaction from some international law folks, but much more positive reactions from colleagues around the country in the federal courts area and in the domestic constitutional law area. So we were bucked up a little bit by that other kind of support. And over time heals everything. A lot of new faculty members are coming into international law, and lo and behold, a number of them start thinking kind of in the direction that we had been thinking in the 1990s. Sometimes agreeing with us, or maybe not entirely agreeing with us, but at least being receptive to rethinking the field. And probably also helped both of us in very different kinds of ways that our later writings clearly demonstrated that we're not opposed to international law, and indeed quite receptive to it under certain conditions, if certain processes are met. So the charge that I think Hankin and Newman wanted to make, they're just against international law, increasingly lost force as additional work is being done. We began focusing on a lot of other issues. I've introduced the customary international law issue. Jack Goldsmith and I writing often separately, but sometimes still together. A key theme, and Professor Helfer mentioned this, of our work over time is that in an age of globalization, having a sharp distinction between domestic affairs, which have vigorous constitutional law associated with them, and foreign affairs which do not, is increasingly untenable. At least that was our argument. And that domestic constitutional law understandings need to be brought more to bear on thinking about the United States' role in the world. So we brought what we thought, the U.S. Constitution, separation of powers, and federalism, two issues of international law in a way that we thought was timely given the extent of globalization. this was a response to that effort more generally by Professor Peter Spiro, that we're now called the New Sovereigntists, American exception as false prophets. So bringing constitutional law is sovereigntist. You know, sovereignty, I guess, is bad. So we're the false prophets. We responded to that by a 2-sentence little letter to Foreign Affairs Magazine saying, you don't have to call us that, just call us constitutionalists. That would be fine. You don't have to call us sovereigntists. Other critics were not as kind as Peter, actually. So Jose Alvarez, who's now at NYU, labels Jack and me and a couple of other people I'll mention as the 4 horsemen of the constitutional apocalypse. There's an illustration of us. You can figure out which one is which. So it's me and Jack Goldsmith, John Yoo, you've probably heard his name at Berkeley, and I should add, our own Ernie Young, and now at Duke. So we've got a fair amount of the horsemen covered at Duke already. And not only do we have horsemen covered, I think we now have pony riders of the apocalypse, like Professor Mithu Galati, who hangs out with some of the horsemen. There's a danger that other of my friends will be tainted by apocalyptic sensibilities. So I worry, for example, of Professor Helfer, a friend of the Dark Riders. So apologies for anybody who gets mixed up in that. So we published this article, obviously a lot of consternation going on. We then started to try to organize additional efforts to rethink the area. It was the end of the Cold War. I thought this was a really good time to think about it. So I was at my first teaching job at Colorado. Jack came over and we brought a bunch of people. I can't even show you the full symposium overview, but a lot of people who have now gone on to do significant work came to Colorado in the late 90s to talk about different aspects of foreign affairs law and how it might be subject to re-examination in these times. And that was a significant conference, and a good time for rethinking conventional wisdom. I went on to join the UVA faculty, where Jack Goldsmith had been, on the theory that the two of us can never occupy the same space at the same time. He immediately goes to Chicago, even before I get to Virginia, but that's where I'm at. And I start writing, and he does too, about the relationship between the treaty power and American federalism, when treaties can be enforced in the United States, so different than custom, the constitutionality of the United States giving authority away to international institutions, the proper scope of human rights litigation. I'm going to say something more about that in a minute. Jack and I also go on, and this is an introduction to that Colorado symposium saying it's time to start thinking about these issues again. I wanted to mention another person at Duke. So I developed a casebook with Jack on foreign affairs law, teaching at UVA, and it's in the page proofs early on. One of the first users of the book at UVA, maybe the very first user, was Rachel Brewster, who went to Harvard, is now at Duke. So probably another pony or a friend of the Dark Riders as well, but one of my students at Virginia after we introduced our casebook. It wasn't even finished, I think, when Rachel took the course. It's now in its 4th edition, U.S. Foreign Relations Law. And I remember teaching out of the page proofs because it was also when 9/11 happened. We had basically no materials on terrorism at that time, and terrible events, of course. I was literally teaching foreign relations law at the University of Virginia that morning, walked out of class, and it was then that my students were in the courtyard and they started telling me about what they were seeing on the internet. And I first, of course, felt the tragedy, but within a few days, I'm also thinking, another tragedy, I got to fix this book, because we got nothing on these issues, and we quickly added materials on terrorism. And we thought this might be a temporary, we hope, maybe a temporary focus of the book. For better, for worse, this is now 2013, and larger and larger portions of the book are about the so-called war on terror. Things like military detention, military commissions, electronic surveillance, targeted killing. These are big issues still, and they were. We just started to see they were going to be big issues in the months right after 9/11 and put some initial materials in the casebook. It also influenced our career choices. So both Jack and I decided to go into the government, in part because of the difficult issues that we could clearly see were coming up. And I went to the State Department. They have an academic post for a year called Counselor on International Law. Jack, as probably you know from books he's written about it, went to become the head of the Office of Legal Counsel about the same time, in around 2004. These were tough times. When I got to the State Department, the torture memos were leaked out, and the State Department had to figure out what to do about those. We were trying to give sovereignty over to the Iraqis. There were the big terrorism cases had finally reached the Supreme Court, like the Hamdi case, all happening when we were in the government. These were interesting times, but very challenging times. And it was, by the way, just to make another Duke note, While I was at the State Department in that ugly building there, is when the former Dean Kate Bartlett stopped by to try to persuade me to come here. As you may remember, she's there, and that actually helped bring Kathy and me to Duke. So that was a fortuitous time for us then as well. So we're doing all of these projects. We're doing the government service. By the way, right as we got out of the government, we figured we needed to bring some of our knowledge or thinking about, particularly the war on terror, to academia. So we wrote an article, 2005, trying to set up a framework to help the government in particular think about all these things about targeting and detention and trials when they had so little guidance from the Congress. And they still have relatively little guidance from the Congress and some of that. So this is when we had almost nothing from Congress other than just an authorization to go out and fight al-Qaeda. And so we tried to set out some ideas for how to put some law structure into this thinking, and maybe also help the courts, because we could see the courts were going to get involved as well. And very importantly, a big emphasis of that article is the importance of using principles of international law, including customary international law, to help inform the framework. So who would have predicted it, maybe from 1997, but that was actually a big part of what we were thinking. And one of our great things we're proud about from that article, it's used heavily, maybe you might expect this since we worked in the Bush administration, by the administration in trying to figure out its arguments, and also by some of the courts, but then equally heavily by the Obama administration, have used this at least as much as the Bush administration in trying to think through these issues. And here's an example from a recent DC Circuit Court opinion. As we put it in that article, and this is an argument that if the international law of war can inform what powers Congress has given the president, which clearly the president thinks is true, they can also put some boundaries on the powers. That was actually one of the key themes that we set forth in that Harvard piece in 2005. The pro-international law position, actually. The other conservative judges on the D.C. Circuit, there was a long opinion by Judge Kavanaugh that has the flavor of, I like almost everything Bradley and Goldsmith's ever written, except for that bad article. And Williams said, no, this seems about right, that there ought to be some limiting aspect to international law as well. And we had a symposium on this piece at Harvard, and I just found, I dug it out, the Harvard Law Review decided to put up little posters about it, so this is the poster for us. I guess I'm 006, so there's Jack, so that, that was kind of nice. Lots of different issues, including obviously the war on terror. We never left entirely the debate over customary international law. One area where it comes up a lot is something called the Alien Tort Statute. It's an old statute, 1789 statute, one sentence long. Let me have a slide on it. Yeah. This is the entire statute. It's all it's ever said for 200-something years. It literally gets buried in the statute books. Nobody basically knows about this statute for 190 years. And then a federal court in New York famously discovers the statute and holds that victims of human rights abuses around the world who are aliens can sue for those human rights abuses, which are torts that violate modern international law of human rights, and they can come to American courts and bring those suits if they can find the perpetrator and they can serve them with process. And that case was a case about a torture of somebody and killing them in Paraguay by a Paraguayan chief of police. And that was 1980. Ever since then, there's been a number of these cases from every conflict zone in the world, basically. There have been human rights cases in American courts brought under that particular statutory provision, including cases, some from situations that are, places where, we've had true conflict, like in Yugoslavia when it broke up. Radovan Karadzic of the Bosnian Serb gets sued under the statute, but also against, countries where there isn't quite the same thing. So many suits against China, for example, by the Falun Gong. Anytime anybody from China tries to come and speak to the United States, the Falun Gong rush through their bodyguards to try to sue and get these suits into courts. Israel is often sued for activities, controversial activities in the Middle East. So a wide variety of cases. Well, we had questions about turning this into a human rights statute. Not moral questions. There are good arguments for giving a voice to victims of human rights abuses. There are good arguments for giving some remedies to human rights that often has none. We didn't really take issue with that. Our concern was the 1789 statute was just being asked to do too much work. It doesn't say anything about the kind of claims you could bring, the limits, the kind of defenses the defendant might be able to argue, statutes of limitation. Anything you would want in a normal claim statute is just absent from this law. And it's clear the 1789 Congress couldn't have even thought of any of those issues. We didn't have human rights law in 1789. So our argument was Congress really, if they want more of this human rights litigation, they really ought to take charge of it, and it should not just be done just purely by the courts. The other thing that bothered us is that you cannot sue under treaties, human rights treaties. Why? The Senate and the President every time have said you can't, and the courts respect that. So instead of relying on the International Covenant on Civil and Political Rights, the U.S. has joined this major human rights treaty, the litigants just call those violations of the ICCPR violations of the law of nations. And they say you don't have to have any worry about what the Senate and the President does for that. You can just sue. And by and large, the courts agreed with that, but we were thinking that this was problematic. This really irritated people. We wrote an article early on, the current illegitimacy of human rights litigation. The human rights community did not respond very favorably to that title. But if you read it, it's not about it being illegitimate as a normative matter, as a moral matter, but really just as a process matter. We shouldn't decide to basically make our courts a human rights court for the world without some legislative involvement in that very significant enterprise, particularly since it does generate a lot of complaints from some of our partners and allies abroad. So that was basically our argument. I went on to think more about the statute. I wrote an article some years ago just looking at as much as I could find about the original history of the statute and the early thinking about it in the beginning of the United States. And basically I concluded, and I think this is basically right, having gone back to it again recently, is the statute was designed for situations in which the United States would be responsible for the tort. Most notably, that would occur when there's a tort in the United States. An assault on an ambassador in Philadelphia was one of the pre-cases, actually, that probably they were thinking about. And we would want to make sure the federal courts, our new national courts, were available to hear cases where the U.S. might be responsible for providing redress. I'm pretty sure that was the purpose, but it's hard to know. We don't have much in the language of the statute. If it is the purpose, it is not at all about remedying Paraguayan abuse in Paraguay or about whatever the Israelis do or the Chinese do in their own borders. The statute has nothing to do with that. You might want a human rights court for that, or you might not, but this statute was probably not designed for that because the United States is not responsible for those sorts of activities. The Supreme Court does come along many years after the 1980 cases and finally weighs in a case called Sosa against Alvarez-Machain, a weird drug kidnapping case that may not be the best precedent. I won't say much about that decision. They're finally addressing the Alien Tort Statute. Souter, like him or don't like him, he's not always the clearest writer, and this was great for law professors and lawyers who wanted more cases because nobody literally understands what this case has to say about the Alien Tort Statute, other than it appears to say, okay, you can keep bringing some of these human rights cases. It does appear to say that, but how many, what kind, what limits? Nobody particularly knows, which means the judges are all over the place since 2004 on whether to allow ATS, Alien Tort Statute, cases. Well, the other thing we thought we saw in Souter's opinion, maybe this is wishful thinking, is when he gets to customary international law, which he kind of has to because these are all law of nations cases, he explains that the reason you can apply those customary norms when he does allow it is because Congress, in effect, has authorized those applications in this old statute. Now, that's a strange claim, it turns out. How do they? He talks about them kind of not really authorizing it in 1789, but that if we recapture what he called the ambient law of the era of 1789, it becomes an authorization. Weird statutory construction. But it's about Congress having authorized those applications. And we wrote an article, Jack Goldsmith and I did, saying if that's true, that he had to look for Congress to authorize, then the argument that it automatically is federal law seems not to be the case, even under this recent decision. And we made that argument in another paper with a young professor, David Moore. This statute, as you know, the Alien Tort Statute, you may know, is pending before the Supreme Court in the Kiobel Royal Dutch Shell case about whether corporations can be sued under the Alien Tort Statute, about the extent to which the ATS applies abroad. So we could get a blockbuster decision literally any day, finally, from the Supreme Court, hopefully clearer than the Sosa decision from 2004. Customary international law is also coming up in a lot in criminal cases, not because courts are saying it's federal law, and this is something I've often emphasized in my writings. Even if it's not federal law, U.S. courts might take account of it when interpreting federal statutes, and they do. So the idea is that Congress doesn't lightly intend to violate international law. So in a criminal law, for example, that we're trying to figure out whether it applies in Panamanian waters or something, courts do look to see whether that might violate international custom. And I've actually been quite supportive of that for many. This is the Kiobel case for many years. I've written an article many years ago about this famous doctrine, the Charming Betsy canon, that says we should interpret statutes to avoid violations of international law. I've been quite supportive of that. And then, of course, Goldsmith and I were very supportive of that idea in connection with the War on Terror, which was one of the points that does get picked up by the courts. One of the things that's helped us, I think, over time, get a sense that maybe we're doing pretty well in the customary international law debate is that in 220 years or so of history, there's still not a single decision in the history of the United States ever holding that customary international law is federal law. So the lack of precedent is just now so stark, and now finally the courts, and this is an en banc Ninth Circuit decision, usually very liberal about these sorts of issues, said just in 2011, if you read it carefully, that after Sosa, that without a statute, it would not be considered federal law. That was our argument. It's the argument we made forth in the 2007 article specifically about the Sosa case. And for the Ninth Circuit, which is usually very receptive to these claims, in an en banc decision to basically dismiss the Restatements claim is certainly giving us, I think, more traction on what we had originally argued in the early days. So it's a story of two young academics riding around convertibles, not knowing exactly what they were doing, running into some heavy opposition, but I think eventually clearing out some space for other people who are interested in these issues. Eventually we become mainstream. We work in the government. We write case books. We get cited sometimes by courts. We've taught a generation of students now, some of whom are actually themselves in government or in academia. Now I'm serving as a reporter on the Restatement of Foreign Relations, the very kind of enterprise I critiqued some years ago. Also, kind of ironically, Jack and I are now kind of lumped with Harold Coe, the old nemesis, and kind of having this vigorous amount of scholarship. What's likely to happen? You know, there'll be a time when we're the old fogies, and I'm the terrible person on the Restatement, and I'll be attacked by some new generation, some new young people. I'm hoping I don't give them quite as hostile reception as we got, but I can't promise that. I might get crankier over time. Who knows? So that's a summary of sort of the intellectual history of the book, and I just had a couple more things I want to say. So this is the book. I want to emphasize the book is not about pushing the positions on customary international law or some of the other things I've written. Those are in my articles. You know, they're on the internet. They're free. You can go ahead and read them if you ever want to. This book is an attempt to capture what my best sense is of the currents of the law right now, not necessarily how I would always like to see the law go. So, for example, when I've written about the treaty power and federalism, which is one of the topics I have written about, I didn't talk about today, I think I'm out ahead of probably where the courts are going to go. And so the book is really talking to students, judges, lawyers about where we've been, what the debates have looked like, so people understand the competing arguments, but really an effort to capture kind of the center of the law, not an effort to really push it in the way that Jack and I and others were trying to do some years ago. Just to give you a sense of what it does cover, it's a lot more than what I've talked about today, the role of the courts, treaties, these other things called executive agreements, what to make of international institutions when they issue orders about the United States, customary international law, I did talk about that, applying U.S. laws abroad. I talked about alien tort statute litigation today, but also immunity questions. You know, when the Falun Gong sues the president of China, happened when I was in the State Department, what happens? I talk about that. Criminal areas, and then significantly, of course, still issues about the war on terror, which has a lot of international issues. I'm going to wrap up by doing one thing, because I had a conversation with my daughter, actually 11-year-old daughter, about the book. Not about all the substance in there, but about the cover. And she is actually very good at art and artistic design. So I said, here's the cover. And I said, Oxford spent a lot of time working on the cover. And she paused and she said, Dad, you do realize that's just two colored squares, right? So I had to explain there's so much more going on in that. First of all, easy point, as you may immediately notice, it's an abstract representation of the American flag. And it is about international law in the U.S. legal system, so that probably makes sense. But there's a lot more, it turns out. So yes, two squares. But they must represent international law and U.S. law. That's obviously what the title of the book is about, that they are representing those two things. And note how they overlap. That's true. They do overlap in practice. But here's the key point. They produce something different. It's not red and it's not blue, something different in the intersection of international law and domestic law. And that actually is a key theme of the book. is that when and Professor Helfer mentioned in his introductory remarks, when international law comes into the United States, as it does, in a lot of direct ways, but also many indirect ways, it produces something different. And it's not the international law of the International Court of Justice, or the International Criminal Court, or the professor writing in The Hague. It is something unique, sometimes uniquely good, maybe sometimes not, unique to the United States in a variety of ways that I talk about in the book. More subtle, perhaps, you note how the two things are intersecting, but it's impossible to tell which one has primacy. Is the blue on top or is the red on top? We don't know. And that subtle point is quite right. There are times when the relationship is still, even today, maybe we'll find out from the Kiobel case and others, what that relationship looks like, but it's quite undecided. But there's more. You hope there was. There is more. So sometimes discussions about this topic, sometimes unfortunately, overlap with another divide in the United States, which is, of course, the political and partisan divides, which we've seen very robust in the last presidential election. And, of course, that is a debate between the red states and the blue states. And we may have some representation of that divide here, and I think we do, but there's hope, because a significant amount of overlap exists between that partisan divide. And that sort of hope, completely unrealistic, of course, is, I think, it's quintessentially American, which again takes you back to the American flag. Now, I actually got through not even 5 seconds of that with my daughter before she turned on Nickelodeon and said, I'm blocking her view. But I have a captive audience, so I hope you enjoyed that graphic presentation. So thanks for listening. It's been a joy to work on the book, and I really like talking about it, as you can tell. If you have any questions about what I've described, the kind of intellectual history and academic, what counts as drama in the academic community, happy to talk about that. Or any issues relating to some of the topics I mentioned that the book does cover. I'd be happy to talk with you about them. Thanks.
Congress can go with the define and punish clause? I mean, can they just make it up if they want? Or
yes. This is now what Professor Dunlop is asking about, is that power of Congress to define and punish offenses against the law of nations. Congress is using this power more now, and what the executive branch would like to argue in some of these cases, which has come up very recently, is that basically anything the government claims is a violation of the law of nations, the court should accept. I think that is wrong, because if it's true, that would give the Congress unlimited power to make law, which we normally think is not the way we read the Constitution. So this came up actually just a couple months ago in a case involving drug trafficking, 11th Circuit case, where we actually seized a Panamanian vessel with non-U.S. citizens for engaging in big-time drug trafficking. The problem is it's very hard to show they were targeting the drugs of the United States, or where they might end up with those drugs. So the statute lets the United States, particularly if the Panamanians consent, grab them and prosecute them without any real connection to the U.S. being proven. So the government argued, well, that's a violation of the law of nations, trying to deal with all these big-time drug trafficking. And defer to us, said the executive. And the 11th Circuit said no. As they looked at it and they didn't find enough support under international custom for calling that a violation of the law of nations. That approach, taking a second look, with some deference, I think, obviously to the expertise of the government, seems to me to be right. It's coming up, as Professor Dunlap knows, also in the military commissions, where there's a decent argument that their jurisdiction, for a variety of reasons, is limited in most respects to prosecuting things that also violate international customary law. And the D.C. Circuit, otherwise very pro-government in the war on terror, not long ago threw out the conspiracy prosecutions, or military support and now conspiracy prosecutions, relating to these military commission prosecutions on the theory that the government hasn't shown those are really violations of international law as opposed to some kind of common law of the United States. And I basically agree with the methodology, which is the courts kind of have to have their own views. There's some question about how much deference, I think, to give to the courts. Yeah, Scott. Yeah,
Kurt, on that point, the government conceded in its briefing in Balliol that not only material support but conspiracy and solicitation are not traditionally cognizable.
Right.
Because they're not violations of law of Hong Kong.
They did, and that made it a lot easier for the DC Circuit because they didn't have to worry about should we defer to some extent to the international law views of the State Department and the government, because they gave up on that argument. They said, we concede it's not. I don't know if they should have made the concession. Maybe they realized that they wouldn't have won either way. But then the DC Circuit said, you've conceded it doesn't violate international law, and we think you have to show that. And so it became a very easy decision. That case may well go up, and we'll see if the Supreme Court has a different perspective on it. So it's coming up in the drug cases. It's coming up in the military commission. It's also coming up in piracy cases. We now have a rash, the Somali pirates coming to U.S. courts. And that is also about punishing things, piracy as defined by the law of nations. And so the courts are actually having to figure out what does the law of nations really say about piracy. So the same kind of framework in those other cases. Yeah, you do.
Yeah, they should have had you host the Oscars, I think. So, just pushing your point to the extreme when you think about it from the international perspective, what is the implication then for customary international law status more globally? And what does that mean then for how the U.S. would act, say, vis-a-vis North Korea?
Yes, completely fair point. So one of the things that certainly in the government I became even more appreciative of was what implications do positions we take have for our concerns about what other countries do, an absolutely fair concern. The United States, as far as I know, has not insisted that other countries internalize customary international law in a certain kind of way. So in some countries, it's not internalized automatically at all. It would have to go through the parliament or the legislature. In some countries, it is more directly internalized by the judiciary. And as far as I know, the U.S. does not insist on one method or another, as long as the nation complies. So ultimately, the question is, sort of take your question one step further, does my criticism and sort of my preferred approach, which is to make Congress do more of the work, would that reduce our compliance with customary international law? If it did, that might create problems for the United States because it could induce other nations. And I have not been persuaded that it does. For the human rights area, where it's most controversial, the norms that are claimed in court to be custom are identical to the norms in the treaties we've already ratified. So if there's a compliance problem, it's actually a treaty compliance problem. And I think persuasively, to my mind, the government says, even when we don't make the treaties domestically enforceable, we actually are in very large-scale compliance. And if that's true, that would also be true of the custom. And many issues also, I should emphasize, should never come to the courts. If you think of a lot of international law, it has nothing to do about the courts. If the NATO pact says we're going to defend Western Europe from attack, I think that's not about federal judges ordering the U.S. military to go defend Western Europe. It's something about our honor and reciprocity. Much of international law of the sea, when we can seize vessels, it's not really about this story. It's a story about, does the United States take international law seriously? And I think that's a different story than the democracy story, which is how do we make this law in the U.S. and override things that the U.S. people have otherwise chosen, on the death penalty or something like that. So as long as we're complying, I think we'll be okay on that.
Colonel, I wonder if you could say something about how your views have evolved since the 1997 article, because
yes.
there, you set this up in a way where you note that some of the statements in the restatement had thin support. And certainly that's true, and that led you in a particular direction that kind of pierced through to the center of what a current way of thinking was among a certain group of scholars. I think that's fair to say. But it strikes me, knowing your work as I do, that your views actually have evolved over the last 15 years or so. Right. And I wonder if you could say a little bit about how they evolved and what were the influences that caused them to evolve.
You're absolutely right, and I say this with some pride. Sometimes people don't like to say they've changed their mind about anything because you're wishy-washy. Why don't you stick with your position or something? And if you looked, we wrote an article on customary international law in 1997, the first big article we wrote. The style of it, as I go back to it, is probably not exactly the style of it. It's a little bit pugnacious. It's punchy. It says everybody's wrong and they've been taking it for granted. We're not that kind to the senior folks. They thought it was probably okay to be unkind to us in return. I stylistically try, partly if you've been around a long time, most of these people you now know, they're your colleagues and friends. There's a different kind of interaction. So but that's stylistic. That's not. I actually think most of the merits of that article are still right. But it is, one thing I've learned is it's very easy to take a problematic kind of target and then attack it. and then, poke all sorts of holes in it. That's actually kind of easy. It's fun. We had a great time doing it. It's harder to then reflect back on what the target should look like now that you've poked all the holes in it. What does make sense? What's left of it? And we didn't have to do that then. We were just dramatically taking it on. And later, 10 years later, we're actually now thinking, if we were going to redo what they said, how might it look? And so that's a harder task, because then we're now going to be attacked if we get it wrong. And also, what changed? You get older. You learn. Hopefully, you'll learn a few things. I was like 2 years into teaching or something. I didn't know anything hardly about this stuff. I've taught for 20 years almost, and I learned from my students. I learned from being in the government before we wrote the other SOSA piece. And one of the changes we did, not changes, but amendments, friendly amendments, we said was we do think that there are select instances where U.S. foreign relations law will invite bringing in principles of customary international law selectively for certain kinds of topics in ways that would inform the doctrines the courts would apply. So I think a pretty easy example, right now there's no statute or treaty on the immunity that the president of China gets in U.S. courts or other officials get. If there's no treaty and no statute, does this mean there's no immunity? No. I certainly appreciate in the government there's a strong foreign relations law interest in having some kind of judicial doctrines that protect our concerns in that area. So this is a common law doctrine of immunity. Professor Elfer and I have actually written about the international law side of this not long ago. And Jack Goldsmith and I did acknowledge that in select areas like that, international law would be part of the materials one ought to consult in thinking about the common law rule. It's not the only set of materials. There might be other things like what Congress has already done that would be quite informative. That was exactly the approach we took on the war on terror, which was international law did not control everything about what the Bush administration should be doing for a variety of reasons, but it should inform some ambiguities. It should be taken into account along with U.S. historical practice and the text of the statute in creating some standards that actually impose some limitations on what the administration was doing, and now the Obama administration is doing. So it's very much like that work we had just done right after government, and I think very much the same way selective. It was a part of the landscape, but not completely controlling in the way the restatement originally said. But that is more nuanced. And it's okay. It's okay to change your mind, too. If I thought the old article was completely wrong, I hope I'd have the guts to say, you know what, I messed up. And here's it. But I haven't yet been persuaded that that was true. But it has modified over time. You're absolutely right.
Time for a couple more questions, if anyone has one.
Professor Gulati, one of the pony riders of the apocalypse in the back.
So, I like the historical story, especially with respect to the alien tort claim part of it. But at that point in time, the U.S., their role in the international system was a rather minor role, and they were hoping for advancement.
Yes.
Today, with all the statements and the actions of the United States in terms of policing the rest of the world, maybe the Alien Tort Claim Statute makes a lot of sense. And so, more generally, you and I do this in our work too, we go back and we say, oh no, if you look at the original understandings, it's so inconsistent with today. But you're the one who's constantly pushing back and saying,
yes,
well, in the modern context, a lot of this actually makes sense. And if at all there is one place in the world where you can trust the courts to prosecute, it might be here. So if we take that optimistic view of U.S. courts, then this makes a lot of sense.
Yeah, I should emphasize, a good question. This is not, I do not primarily make any originalist arguments about the Alien Tort Statute. When I talk about what I found about the original history, it's actually largely just responding to people who were, Anne-Marie Slaughter had famously written a paper about the Alien Tort Statute, which she's saying that it was supposed to be this big badge of honor to invite everything from around the world. In 1789, I didn't think so, and I said it was not true. Perfectly good response is, okay, that's fine, it had narrow purposes, but maybe it should evolve or change in light of a lot of other things that have happened, including the role of the U.S. in the world and in international law. And most of my writing is actually about that, how actually the role of the United States and the changes in international law make it worse, not better. So why? Human rights law, which is probably the most significant thing that's ever happened in international law since World War II, hugely important, hugely positive in many ways, also poses tremendous challenges for figuring out what one national court ought to be doing with respect to policing with other nations. And whether you're a superpower or not, that should be a set of issues. The reciprocity concerns that have been asked about have been very significant for some of these modern cases in ways that would not have been true in the early days. So in the Kiobel case, a number of Britain and the Dutch and others have filed briefs saying they don't like this stuff. And so that's a very modern kind of development. So, and that's actually the focus. And I entirely agree that if one's going to critique kind of how it's working, one ought to think about where we're at right now and the kind of doctrines we're getting. And I actually think that makes it, if we just stuck with only the things that were allowed in 1799, we probably wouldn't have very many problems. And so I actually think it invites more involvement by the legislative branch rather than less. Perfectly fair question. Yeah, Tim.
Push Judith's question and your response to it a bit further. If the argument is that international customary law, at least, doesn't become actionable in courts unless it's actually explicitly turned into domestic law, and you apply that on a global scale, is there really no implication for what actually international customary law is?
There's no, say the last part again, sorry. There's no
what international customary law actually is. It seems like then there's actually really just a bunch of separate domestic laws, yes. Which you might connect to some loose umbrella, right. But is that meaningful anymore?
Fair question. So the traditional doctrine of customary international law does not primarily rely on court decisions for its content. It primarily relies on actions like by the executive branches of states and sometimes by their legislature. So all that's going to occur. So if the United States is creating new custom about how to deal with non-state terrorist organizations, it's not primarily doing it through the courts. It's primarily doing it through actions and policy pronouncements and things like that. And that has usually been the dominant piece of evidence, and that will not at all be affected by. There are a few areas, though, like immunity, which is more judicial, and so it is true that what you might end up is different national perspectives on it, but that's going to happen whether it comes out of the executive, Congress, or the courts. You'll always have different kind of national perspective. And the other thing I would say, one of the great developments in international law in the last 50 years, is there are international courts now. They are not subject to the questions I've been raising about the special role of US courts. They apply customary international law routinely. They develop it in ways that often cause other nations to coordinate around it. So on immunity, the International Court of Justice just the last year has issued a hugely important decision, Germany versus Italy, saying the Italian courts had to respect Germany's sovereign immunity, even about the World War II conduct. Other nations will probably go along with that, and that will set a kind of a standard in a much more legitimate way, which is an institution where states agree to delegate authority to it, rather than the US claiming we get to decide what international norms require, which has not gotten a favorable reception on a lot of these questions. So if you're going to do it, we've often said it'd be better to do it in these kind of institutions, not through the US thinking it's a police person for the world. So that'd be my view.
So we are out of time, but Mr. Bradley will be signing copies of his book, which are for sale outside in the loggia. So please again join me in thanking him for a very stimulating.